Hello everyone, this is Nilesh Gavande and I am here today to discuss the topic assigned to me, rights of unpaid seller. So let us start with the meaning of unpaid seller. Meaning of unpaid seller. The Sale of Goods Act 1930, hereinafter referred to as the Act, defines an unpaid seller as a seller that has not been paid the full price of the goods that have been sold or that have received a bill of exchange or other negotiable instrument as conditional payment, and the condition on which it was received has not been fulfilled. In simple terms, unpaid seller means a person who has sold the goods for a price but price has not been paid to him. Next, we move upon to the rights of unpaid seller against buyer. There are four rights of unpaid seller against buyer. Firstly, suit for price. Second, suit for damages for non-acceptance. Third, repudiation of contract before due date. Fourth, suit for interest. So let us move on to the first right, that is suit for price. Suit for price. Under the contract of sale, if the property of the goods is already passed but he refuses to pay for the goods, the seller becomes an unpaid seller. In such a case, the seller can sue the buyer for wrongfully refusing to pay him his due. But say the sale contract says that the price will be paid at a later date irrespective of the delivery of goods, and on such a day, if the buyer refuses to pay, the unpaid seller may sue for the price of these goods. The actual delivery of the goods is not of importance according to the law. In simple words, the goods are delivered to the buyer and the price will be paid at a later date. And if price is not paid, the unpaid seller can sue the buyer for refusing to pay. Second, suit for damages for non-acceptance. If the buyer wrongfully refuses or neglects to accept and pay the unpaid seller, the seller can sue the buyer for damages caused due to his non-acceptance of goods. Since the buyer refused to buy the goods without any just cause, the seller may face certain damages. In simple words, here the seller can sue the buyer for non-acceptance of goods without any specific reason which caused certain damages to the seller. Third, repudiation of contract before due date. If the buyer repudiates the contract before the delivery date of the goods, the seller can still sue for damages. Such a contract is considered as a rescinded contract, and so the seller can sue for breach of contract. This is covered in the Indian Contract Act and is also known as anticipatory breach of contract. In simple words, the seller can sue the buyer for cancelling the contract before the date of delivery of the goods. Fourth, suit for interest. If there is a specific agreement between the parties, the seller can sue for the interest amount due to him from the buyer. This is when both parties have specifically agreed on the interest rate to be paid to seller from the date on which the payment becomes due. But if the parties do not have such specific terms, still the court may award the seller with the interest amount due to him at a rate which it sees fit. In simple terms, when both the parties have agreed to the interest paid by the buyer from a specific date, and if the buyer does not pay, seller can sue him for the interest due. Next we move on is to the rights of unpaid seller against goods. There are three rights. Firstly, lien, second, stoppage, and third, resale. So let us move on to the first right of unpaid seller against goods, that is lien. Lien is a right which seller of goods can exercise when a buyer has not paid the price of goods. Under this right, seller can retain the possession of goods as an agent or bailee for the buyer. The seller can retain his possession as per section 47 under the following circumstances. Firstly, in case the buyer is insolvent. Second, when the term of goods sold on credit is expired. Third, goods sold without any stipulation as to credit. In simple words, if the buyer has not paid the price of goods, seller can retain the goods of buyer as an agent, still the amount is not paid. Second, stoppage. When the goods have been transferred to carrier or bailee for the purpose of transmission to the buyer, who has become insolvent, the seller has the right to stop the goods in transit in order to protect himself against the loss that may arise due to insolvency. As per section 50, there are four essential requirements for stopping the goods in transit. First, unpaid seller. Second, buyer insolvent. Third, property should have passed to the buyer. Fourth, property should be in course of transit. In simple terms, if the buyer becomes insolvent and the goods are transferred to the carrier or bailee, then the seller has a right to stop the transit of goods in order to protect himself against loss. Third, resell. Exercising the right of lien or stoppage does not rescind the agreement, but reselling of goods does. And without this right, the other two rights of lien and stoppage will not be of much usage because he can only retain goods under this right till the buyer pays back the money. In simple terms, by lien and stoppage, the agreement is not cancelled, but reselling of goods can cancel the agreement between the buyer and the seller. By this, I come to the conclusion of my topic. Thank you so much for your patient listening.